Okay, Jefferson County Court at Law number 2 is back in session. The court is in session. Cause number 23 CCCR 0020. Case is styled the State of Texas versus Daniel Troy LeBlanc. Let the record reflect that Daniel Troy LeBlanc is present in court with his attorney Ryan Matuska. And let the record also reflect that the state is present with Assistant District Attorneys, Attorney Colby Hoffmeyer and Attorney Lamar Johnson. Let the record reflect that the state has filed a motion for bond revocation. The court has conducted a hearing based on the state's motion for bond revocation. And after hearing testimony from the witnesses in this bond revocation hearing, the court finds that looking at, well, first of all, the court would take judicial notice of the court's file. And also looking at State's Exhibits 4, 1, State's Exhibits 4 and 1, actually, State's Exhibit 4, State's Exhibit 1 actually is a continuation of State's Exhibit number 4. The courts find that in State's Exhibit number 4, on page 1, it reads, and just one more for record, Keon, and it says purpose. My son, the one with me, is as matter of fact also himself a U.S. citizen thereof. He too, under my law, has his right to bear arms also as his legal guardian as of today. He does have his father's permission, for he knows the safety extremely well. His dad's a Marine, but what the F, he used the word F-U-C-K, and it says catch-22 opposing counsel for baby mama called him a child, a minor, so how you gonna handle this one? Or by that same rule, I do not, as his father, give anyone concern to search and seizure of any type. My hand or machine, radio waves, X-ray machine, no part of his person at all shall be screened, or you just violated that American's Fourth Amendment right, which by your rules you did to a minor, so now you mentally harassed and created fear for control purposes to a minor. Looking at that statement and reflecting on the testimony in this case, by Detective Powell, who looked at not only this text message, but the other text messages. Believed that Mr. LeBlanc was going to bring his son to court, both with firearms. Now, also on State's Exhibit number 4, the last page, it says, to the house this morning, it starts off, for those who lie in wait for my arrival, to the house this morning, for the record, please don't harass and threaten with firearms again, for hands on guns, ready to pull it, that is a real threat in this real life, not words, from a fake digital life, but by all means, I do have my Second Amendment right to also bear arms for my own. And that State's Exhibit number 1 was a continuation, and it actually has the same language in the first paragraph that starts off by saying, "For those who lie in wait for my arrival to the house this morning, for the record, please don't harass and threaten with firearms again for hands-on guns, ready to pull it. That is a real threat in this real life, not words from a fake digital life, but by all means, I do have my Second Amendment right to also bear arms for my own defense, just in case. So I will being mine, since you have yours. For if you do recall, while you nearly pulled yours, mine stayed well hid for my control, my self-control, clearly in better submission to the Father above than that of thee. Yes, I indeed, the creator of you and me, let it be a great day. Yes, indeed." So reading this passage, apparently it seems as though Mr. LeBlanc may have went to a house and the people at the house may have had weapons, and he may have had his weapon in self-defense. That's what it seems like. But and I think what he is probably alluding to is what's in the probable cause affidavit, when on the day that the alleged terroristic threat occurred, I think he had went to the house. I think the PC affidavit said he was looking for his children. And I think that the officers on that particular day did a search and did find weapons, or at least weapons on, I think it was a 9mm that they found in the vehicle. And then when we look at I think that was that Monday, the 13th, when he arrived in court, he had a knife and a magazine for a 9mm. He was escorted to his car, and then the case, I would assume, was reset till the 15th, came back on the 15th, and I think this letter, it states Exhibit number 4, it kind of ties in with him being with his son, and his son having the right, well, I guess he's saying he's giving his son permission to carry a weapon, but he's not giving anybody consent. He said, he used the word consent to search him. I guess he was thinking that by him being the father, he had to give consent for them to search it. So that, to me, seems to me it was a plan that he had to perhaps come to the courthouse with a weapon, and or have his son with the weapon and they can't search him. It also appears that when we look at what when he came to the courthouse on the 13th with the magazine and the knife, he could have been testing the security system, which is not uncommon for individuals to do, to test the system to see what they can get into the courthouse or get through the security. The other thing is, I noticed here, he used an example of a movie ending, and in that, let's see, I think he used, let's see, yeah, that's in State's Exhibit 5. Have y'all seen that Wahlberg movie Shooter? And I think he was gloating over the fact that when they was trying to get, I guess, the shooter in a trap, he had a second plan. So it appears to me that Mr. LeBlanc had a plan, but apparently Sheriff Department blew up his plan. And so based on the fact that there was alleged guns involved in the original case, and after he was on bond, the behavior of him still having, I mean, you should have known you can't bring guns to the courthouse. And he still he still was using, I guess, guns to, I don't know if he used the word as self-defense, that he was going to use it as self-defense. But it seemed to me it was somewhat, it could have been, if somebody is receiving this, could be threatening toward them. But anyway, in any event, the court believes that his behavior after being put on bond with these weapons and is not, the court does not believe that the bond is sufficient. So the court believes that the bond is insufficient in its amount for the future safety of the victim, as well as the safety of the community. The court is aware that Mr. LeBlanc does have family ties to this community. The court is aware from the evidence that Mr. LeBlanc has a long work record. He has a lengthy residency in this community. The court has not heard any evidence concerning Mr. LeBlanc's prior criminal history. The court did hear information that Mr. LeBlanc was honorable, that he was discharged honorably from the United States Marine Corps. There is no information as to whether or not Mr. LeBlanc violated any previous bond conditions in any other case. And there is no evidence that there is some evidence that there is an outstanding bond in a civil case. And that civil case, just for the court's record, I have and this is, the court will also take judicial notice of the court's file. This is a document that is in the court's file. And it states that there is a bond in it for contempt of court. Warrant number 230454. I would imagine that's the civil case. And that bond amount was $8,500. And it said it was a cash only to be released on emergency detainer order. So the court is aware that there is he has a outstanding bond. Now, the previous mentioned information about the guns and the mention of guns, and as I would look at his words, that this is a real threat in this real life. And so the court is looking at the fact that bringing guns to the courthouse, bringing guns to, in his court and court's property prior to being allowed to come into the courthouse are aggravating factors that the court is considering in this case. Now, the court is going to set conditions. The court has set conditions on this bond. Those conditions will stay in place. The court will amend the conditions to include that Mr. LeBlanc cannot have any access to any guns during the pendency of this case. And also, so the court is going to set the bond at $50,000. And that's the order of the court.
Thank you.
You're welcome.